By way of introduction, what I'll be talking about with a focus on productivity and the impact of that at least is, of course, Labor's first term reforms. The second term proposals for reforms that are on the table, other developments, including, of course, the recent one table took place in Canberra last weekend, and some recent decisions in the area of workplace law. So my name, by way of introduction, for those who don't know me, is Ben Duggan, and I head up the workplace team here at DW Fox Tucker Lawyers. So starting with the first term of Labor's term in office, in late May 2024, the ALP joining government at the federal level, on this without essentially easy, the party came to power promising a more expansive role for the federal government, and Labor in the area of IR proposed greater regulation and responsibility that took to that election. A short time after coming, there was a jobs and skills summit that was took place in September of 2022. And then in late 2022, Labor, with the support of the Greens, was able to pass its initial bill to amend the Fair Work laws, which was known as the Secure Jobs Better Pay reforms. Labor, as we all know, didn't stop at that point, introducing its closing loopholes bill to the federal parliament following 2023. That bill, of course, was split into two, with the first being passed in late 2023 and the second being passed in early 2024. These reforms were clearly the most substantial permanent reforms to the federal industrial relations system since the introduction of the Fair Work laws back in 2010. These are some of the key areas that have been introduced changes. Introduced changes in the area of outside bargaining, introduced some union rights, in particular for internal union members, which gave them rights for the first time under the Fair Work laws. Introduced reforms in relation to labour regulation, also workplace compliance. My focus will be to talk about the area of labour regulation, which is a day-to-day matter for employers. And the focus of the policy before that election was greater labour regulation, certain labour models that Labor had targeted as fostering insecure work. These, of course, were casual employment, fixed-term employment, and independent contractors. In terms of the first of those, fixed-term employment, Labor's initial fair pay secure jobs reforms addressed that labour model, and reforms introduced provisions that limited the use of fixed-term contracts for the same role or substantially similar work to 2 consecutive contracts or a maximum duration of 2 years, but subject to certain exemptions, which we'll discuss in a moment. And there's also an obligation to convert those on fixed-term contracts to permanent employment in certain circumstances. In terms of the exemptions, they were to, that is, the continuation of fixed-term arrangements beyond those restrictions. They were to perform only distinct and identifiable tasks involving special skills, perform essential work during a peak demand period. Under a training arrangement, the employee earns above the high income threshold for the year in which the contract enters into. That's currently $175,000. The theory being, if you're earning that money, you look after yourself. It is an appointment to a governance position, being wholly or partly government funded for more than 2 years, and there's no reasonable prospect the funding will be reviewed at the end of that period. I might reward them with such an arrangement. And then there were some other exemptions that were later included, which included those relating to sporting organisations. Now, these reforms, of course, commenced in December 2023. What that likely means is that it's likely that it's coming to the end of the period within which you can have those original contracts that you had at the start of the reforms. So certainly in the back end of 2025, you need to consider whether you continue with these arrangements, that is, are the exemptions that are going to apply for you to continue these arrangements next year, or alternatively, you need to consider whether you engage the employees under these arrangements on a permanent basis, or you need to look at some other options. So Labor's later closing loopholes reforms addressed the two remaining labour, being casual employment and independent contractors. Now, over many years, the labour movement had targeted these labour models through the courts, and the legal strategy would involve a worker engaged as a contractor, describe them as a casual contractor, arguing that they were in practice a permanent employee. Finding the court they were a permanent employee would, of course, provide a benefit such as leave entitlement or income support in workers' comp suits. The Labor movement's legal strategy had some significant success. In recent years, though, there were some High Court decisions that were delivered in relation to casual and contractor disputes that have provided primacy to the terms of the contract between the parties. And the High Court's decisions in these matters effectively ended this very successful legal strategy of the Labor movement, because they found in both cases that the work concerned was either casual or a contractor, such that he could get benefits to employment. So Labor's reforms under the closing loophole reforms targeted these two labour models. Really, it was a direct response to these High Court decisions, and we will see from the discussion about that what they've done in the future. The Labor's approach to addressing these models was to make the following amendments to the Fair Work Laws. Firstly, to introduce a definition of employee, and secondly, to amend the current definition of casual employee. Curiously, you would say, wasn't there already a definition of employee there? But there wasn't, other than a very bland definition. It's a natural system employed under the Act. But now there's a comprehensive definition of these two terms. In each case, the definition emphasises the practical reality of the work relationship as opposed to merely the terms of the contract, so getting away from the rationale of that High Court decision. In terms of the new definition of casual employee under Fair Work Laws, the amended definition of casual employee is as follows: that the employment relationship is characterised by an absence of a firm, advanced commitment to continuing indefinite work, and the employee's entitlement under a Fair Work instrument or contract to a casual loading of pay because of their casual employment. There is also, as is the case in federal legislation, indicia for assessing whether there is a firm advanced commitment, and that included significantly consideration of the real substance, practical reality and true nature of the employment relationship, noting that a firm advanced commitment can be in the form of a contract or a mutual understanding. Factors that indicated the presence of a firm advanced commitment included an inability of the employer to elect to offer or not to offer work, a reasonable likelihood of future availability of continuing work, and whether there are full or part-time employees performing the same kind of work. So the new definition emphasises the real substance, practical reality and true nature of the relationship between a work party that engages to perform that work. Now, in terms of the practical effects of these reforms, we can see pretty clearly from these definitions that a departure from the terms of the contract as the primary indicator of the nature of the relationship will afford employers less certainty when they're using either of these two labour models to engage either an employee as a casual or a worker as an independent contractor. And really, frankly, for this reason, it makes it less of an attractive option. I know that in practice, some larger businesses, including those in the retail industry, have, for example, decided to get ahead of this issue by engaging employees who you'd ordinarily think would be engaged as part-timers, which they found a solution around the problem. Casual conversion. This was an area that caused a great deal of angst in the past, because the casual conversion provisions, as many of you would be aware, meant that you, as the employer, had to consider whether or not you needed to offer somebody who was employed as a casual permanent employment, and you had to write about that issue. My experience was very few employers actually complied with the Act in regard to those particular casual conversion requirements. Now, fortunately, we've moved away from that process, and what the government has introduced sensibly, in my view, is an ability for the employee to request to be converted, what's been described as an employee choice model. And that, to my mind, seems to be a much better option to go with, because where an employee genuinely wants to be converted, they would make it a process by which that is undertaken. The employer still has the right to knock that back on their business grounds, but now what can happen is that the worker can now take that dispute to the Fair Work Commission. So the Fair Work Commission has a role in relation to disputes of this nature, as it has in relation to a range of other issues that now apply in relation to changes that are brought about through these particular reforms. The other thing to note is that there's a relatively new requirement for casual employment information statement. We're all familiar with these information statements we need to provide new employees before they start. Well, now there's a new one for casual employment. In relation to that, interestingly enough, there is an additional requirement, leaving aside when the employee starts, for the employer to provide, as soon as practicable, after the employee has been employed by the employer for a period of 6 months for a larger business and 12 months for a smaller business, and after each period of 12 months for which the employee is employed by the employer. Sharing the intention there is that in giving the information statement at that time, that is contemporaneous to the same time that the worker might be thinking about their rights to convert. So that links into their ability to say to the employer, I seek to convert to permanent. So that's presumably the reason why you as the employer need to keep your information statement of that nature during the course of the casual employment relationship. The other area that has had a fair bit of discussion in the media, including recently, is the principle of same work, same pay. This probably is an area where there's been a significant amount of traction for the union and the workforces that they represent. The reforms enable an application to be made seeking a same pay, so same work, same pay order from the Commission. And an application may be made by an employee union opposed to employer. The Commission was prohibited from making such an order in certain situations where the work was to be performed for the host employers truly for the provision of a service rather than for the supply of labour, or where it is not fair and reasonable circumstances. And where the Commission does make such an order, labour hire employers are required to be paid at least what they would receive under a host employers agreement. The union movement's been very successful in utilising these provisions in the last year or so to get orders, many of which have been agreed. There was a recent one involving BHP, which related to what might be described as their internal labour hire firms that they had established many years ago. And there's a fight on in relation to that issue, which BHP is currently using. But effectively, most labour hire firms have simply agreed to that be made, and the effect of which is that they must pay effectively their employees, their workforce, the same as any relevant enterprise bargaining agreement, effectively that's the hosting bargaining agreement, which has led to in some cases, some fairly significant increase in pay, particularly in the resources industry, where these arrangements have been used quite frequently by larger employers. The other thing I wanted to touch on briefly was in the area of flexibility. Now, the closing the loopholes reforms inserted a new section 65 capital A of the Fair Work Laws that required an employer who received a request for flexible working arrangements to meet with the employer to discuss the request, or where the employer intends to refuse the request, agree alternative changes to the working arrangements and don't agree changes. And then if they still intend to refuse the request, outline the reasonable business grounds for refusal and address such matters as changes to the employee's working arrangement that could be accommodated, and that there are no such changes the employer could make to accommodate the employee's circumstances. Again, the reforms have introduced new provisions empowering the Fair Work Commission to resolve disputes regarding such requests. But what that means is that if, for instance, a request for working from home on a part-time basis is received from a permanent employee, if there's no agreement reached, that worker can refer the matter to the Fair Work Commission. And there's been a series of decisions which deal with these matters over the last year or so. Turning now to the Labor's second front. Of course, we had an election earlier this year in May. For that, Labor didn't introduce the comprehensive policy that it did immediately before its first term. It did, however, outline some areas that it wanted to concentrate on and address in the future, in particular these four areas, one involving penalty rates, another involving restraints for trade, support of long service leave, and also wage increases for the aged care and early childhood sectors. In terms of restraint trade or non-EAT clauses, the intention of the government is to have a complete ban on non-compete clauses for workers who earn less than $175,000, and also a potential ban on wage fixing and the use of no-poach agreements to block employees from being hired by competitors. In addition to that, there's legislation that was introduced by the government seeking to prevent Fair Work Commission from removing penalty rates. That legislation has been passed today. So if I just talk, what I wanted to talk about was the two most significant of those being the one involving restraint trade and the other one involving the penalty rates issue. Because again, they're the ones that most practically impact people in general. So you might remember in Labor's fourth budget that the Treasurer had confirmed the government's desire to prohibit non-compete clauses for employees earning below the high income threshold. Now, the stated aim of the government's measure, consistent with its initial reforms entitled Better Pay, Secure Jobs, was to enhance the mobility of Australia's workforce, leading to increased wages for affected employees of up to $2,500 annually. I'm not sure how it worked out those calculations, but nonetheless, I accept that. As we all know, over the last decade, in particular, it's become increasingly common for employers to include restraints in contracts of employment that a departing employee must comply with for a period of time after their employment. The type of activities that these restraints have sought to prohibit include working for a competitor, soliciting former clients or employees, or setting up a business that competes with the former employer. Commonly, these restraints are limited in their scope by reference to time, generally they apply for a period between 3 and 12 months. And geography, generally they apply to the city and state of the individual. A key reason that employers limit the scope of these restraints is to enhance their enforceability, with courts only prepared to impose prohibitions on former employees that are reasonable because they involve a legitimate protection of the interests of the former employer. At this stage, Labor's proposed prohibition on non-compete clauses appears to be limited to those that place restrictions on an employee from leaving an employer to work for a competitor in the same industry, what might be called a work restraint. Courts have, in any event, in my experience, become increasingly reluctant to enforce this type of restraint, which is viewed as extreme, unless the employee has left a very senior role or for some other special reason, like they've got some marketing material or are aware of a particular strategic matter that the employer should be able to protect. Labor's proposed prohibition does not seem to affect other common types of restraints that prevent the former employee from doing the following: performing work for the former employer's clients, so the standard non-solicitation client clause, or the solicitation of the former employee's clients, or the solicitation of the former employee's employees. So it seems to be fairly narrow in its scope. This is a matter that the Treasurer has indicated that he's keen to progress, and it looks as though Labor is introducing a prohibition in relation to restraint of trade sometime next year. So that gives employers plenty of time to consider what restraints they currently have in place, and indeed whether they will comply with what is proposed. But certainly the ones where the standard ones in relation to solicitation of the clients or employees would still seem to be available to employers in future, despite these proposed reforms. The other matter that, as I mentioned earlier, has been passed today is the Fair Work Amendment protecting penalty and overtime rates bill. Now, this reform amends the Fair Work laws to ensure that pre-existing penalty and overtime rates in modern awards are not reduced for workers, and no terms are included in modern awards that would substitute penalty or overtime rate entitlements with alternative entitlements that would reduce additional remuneration for penalty or overtime entitlements that the employee would otherwise receive. Now, this is something you probably think is the case anyway, and you probably think, why was it necessary to introduce this reform? Well, probably it's best explained by way of a technical example. So if you have an enterprise agreement, and this is not uncommon for this to occur, and indeed one of these agreements was the type of agreement Coles sought to have many years ago and didn't get approved. But what you might seek to have is a standard hourly pay for which that standard hourly rate of pay might be higher than the base rate of pay, but it could be slightly less than the penalty rate. Now, it seems to me that the effect of these reforms is that you can't take that approach. Certainly, we have some employers, without mentioning any names, who have taken that approach. One of the benefits of that approach is administrative simplicity, is you know the same hourly rate for whatever work you are engaging, whether it's Monday at 6 o'clock at night, Saturday morning at 11 o'clock, it's the same rate of pay. So it does create a level of simplicity in terms of your operations. My view is that with future enterprise agreements, they may struggle to pass the boot, and indeed this particular provisions that have been introduced that regulate this issue in the future with that approach. It seems to me what this approach is doing is saying if there is a penalty rate, you must pay this. So you can't have overs and unders in that way. So we will try and when I'm right about it, but I suspect that's going to create an effect because I can see that when you get sick through internal bargaining agreements, that's when the issue is going to arise. And my suspicion is that the Commission probably won't approve those agreements where they are paying a standard for all hours worked that is less than what you might get at the penalty rate at other times. Right. Turning now to federal Labor government second term and its forms. At the end, no, the roundtable took place in Canberra. The innovation in Australia. The aim of the roundtable is to build consensus on ways to improve productivity, enhance economic resilience, and strengthen favourite sustainability. And with three main themes. Firstly, making economies effective. Secondly, building resilience in the face of global uncertainty. And thirdly, strengthening the budget to make it more sustainable. The roundtable, as we'd all be aware, is led by the Treasurer. Attendance was by invitation only, so none of us may well have been invited, despite benefits that would have been available to the government if they had been invited. And of course, it took place, as I say, last week. In terms of the roundtable, there were 10 immediate changes the Treasury identified immediately following the roundtable. They included such matters as introducing a road user charge for EV vehicles, the abolishment of what he described as nuisance tariffs, the reform of the National Construction Code, the acceleration of environment legislation addressing backward approvals, reduction of regulation in the National AI Plan. For our day-to-day workplaces, aside from the National AI Plan, I didn't really see how those changes would necessarily have a significant impact on an employer's workplace and indeed improve productivity. In terms of the National AI Plan, the possible regulation of AI was raised in the lead up to the roundtable. Specifically, the ACTU had pushed for an AI Act with an authority and new implementation agreements with employers over the use of the technology. A separate focus seemed to be to work out how to pay media companies and other content creators for the content used to train AI models. Whilst there seemed to be some agreement as to the need for payment to media companies and other content creators for their work, there was not broad support, one might say fortunately, for the ACTU's push for an AI Act and associated recognition, which had the impact of potential impact to negatively impact productivity. The outcome in relation to the National AI Plan was that Innovation Minister Tim Ayres is to accelerate his work on a broader national AI capability plan. Let's hope he doesn't take too long to do that. Otherwise, we could all be left well past starting date. In terms of other developments, in response to Australia's flagging productivity, it's been proposed by some that changes need to be made to our workplaces. The position being taken in some quarters is that these changes should involve the creation of permanent rights for workers that provide them with greater flexibility, this thereby increasing productivity. In Labor's first term, it has introduced greater rights related to flexibility, which have been discussed, and introduce a right to disconnect outside of normal working hours for workers. In each case, the right to disconnect shall entitle an employee to refuse to monitor, read or respond to contact from an employer or third party, read client, outside the employee's working hours unless the refusal is unreasonable. This acts as a right rather than a requirement, meaning the employee may respond or connect out of hours if they wish. A critical aspect of the right to disconnect is whether the refusal to connect is unreasonable, and similar to the criteria for reasonable additional hours already contained in the Fair Work laws, whether a refusal to respond is unreasonable will be determined by a multi-factor test, including an assessment of the reason for the contact, the method of contact, the nature of the employee's role, their personal circumstances, and importantly, whether they are remunerated for the out-of-hours contact. So it seems to me, based on those criteria, much like the question about reasonable additional hours, can be dealt with by way of further remuneration. Interestingly, the Commission has confirmed recently that it's received either limited or no right to connect disputes. So whilst there was some concern about right to disconnect disputes prior to the introduction of this right, much like the bullying application, there hasn't been a flood of applications that's been received by the Commission in relation to this topic. My view, quite cynically about that, is that unlike an unfair dismissal application, it doesn't involve money at all. So for that reason, it seems to me, there's not a pressing reason to pursue such an application. Separately, the Victorian Government has raised the possibility of the introduction of a right for workers to work from home for 2 days per week several months ago. It's unclear how the Victorian Government can legislate such a right, given that, as we would all know, Victoria referred its powers to regulate private sector workplaces to federal jurisdiction decades ago. The federal Greens, though, perhaps helping out the Victorian Government, has separately indicated their support for the working from home right and a 4-day working week as a means to increase productivity in the lead-up to the table. In response, Business Council has suggested alternatives such as boosting investment and innovation, the reduction of red tape, improving planning and major projects, and comprehensive tax reform. I'll now turn to discuss some interesting decisions in the area of workplace. The first things I wanted to discuss was the case of Elisha versus Vision Australia, which is a recent decision of the High Court of Australia. Before I do, I'll discuss the significant decision of Addis and Gramophone, which is House of Lords decision. The facts of that case were that the defendant employed the claimant to manage their business. A part of the claimant's earnings were based on commission. His employment contract specified that the claimant was entitled to 6 months' notice prior to dismissal. After some time, the defendant gave the claimant 6 months' notice. They then took abrupt and oppressive steps to prevent the claimant from doing his job during that 6-month period and refused to pay him. This deprived the claimant of the commission he would have earned in those 6 months. The claimant sued for wrongful dismissal and breach of contract. He sought damages for the following: lost earnings and commission, and hurt feelings, and exemplary damages to reflect the oppressive manner of his dismissal. The issue for the court was to determine was the defendant in breach of the contract, and if they were, what remedies should be available. The House of Lords held that the defendant was in breach of the contract. The claimant had a right under the contract to work to try to earn commission, and the defendants had prevented him from exercising this right. The claimant was therefore entitled to the salary and likely commission he would have earned in that 6-month period. However, the House of Lords held that the claimant was not entitled to any other damages. The principle established by this authority was that damages relating to the manner of dismissal are not an available remedy for common law wrongful dismissal action, and damages for injured feelings or psychological are not usually available in an action for breach of contract. In Elisha, which was handed down late last year by the High Court, the former employee was able to obtain damages for psychiatric injury
from his employer Vision Australia for breaches of their disciplinary policy. And during a disciplinary process that resulted in his dismissal. High Court holding the employee was entitled to damages for psychiatric injury overturned the House of Authority of Patts. I now want to turn to the decision of Qantas. Now, this decision relates to a case where Qantas, at the height of the pandemic, when international borders were shut and domestic travel was limited and erratic, it was in a position of financial jeopardy. Against that backdrop, senior management began work on a proposal to outsource 2,000 ground handling positions at 10 Australian airports. In late November 2022, Qantas decided to outsource the vast majority of directly employed baggage handlers, cabin cleaners and ramp workers. These employees, many members of which were members of the TWU, were anticipating the renegotiation of their enterprise agreements, bringing with it the potential for the employers to take lawful industrial action. In response to this decision to outsource, the TWU took action in which it alleged that Qantas's decision to terminate the ground handling positions was at least partly driven by a desire to head off that protected action. In the earlier liability judgment, Justice Lee of the Federal Court found that Qantas failed to prove that these prohibited reasons played no part in the outsourcing decision. In particular, Justice Lee was satisfied that senior managers were motivated by a desire to prevent the industrial disruption caused by the bargaining process that would likely occur in 2021. This decision that they made to outsource therefore breached the general protection provisions of the Fair Work laws. It's a matter that then subsequently went all the way to the High Court, and the High Court confirmed the decision of Justice Lee. What the Federal Court was dealing with last week was the size of the penalty that should be awarded in relation to these breaches. Qantas accepted that a substantial penalty should be imposed, but it didn't expect the size of the penalty that was eventually granted by the court, which felt, taking into account all the relevant circumstances, that a fine of $90 million was necessary, which is the highest penalty that's ever been imposed in a workplace matter. The $90 million consisted of $50 million to be paid directly to the union and $40 million reserved for further payment, which will be allocated between the unions and affected workers. This is clearly a strong reminder that contraventions of the Fair Work laws can lead to significant fines for employers. The case further emphasises how broadly adverse action and workplace rights can be defined under the Act. It also shows the way in which the onus works under those particular provisions. It's clear that employers need to ensure that they engage in proper planning and documentation to support a business decision, such as restructuring, as Qantas was doing in this case. The final case I wanted to talk about was a matter involving former Senator Reynolds and Brett Higgins, which has been dragging on West Australian Supreme Court for some time. And this week, the court ruled that Brett Higgins, who made some social posts in the course of 2022-23 about her former boss, Senator Reynolds, were defamatory, and ordered her to pay over $300,000 to Senator Reynolds. Primarily, these related to findings that Brett Higgins had famed Senator in several tweets and an Instagram story she posted back in 2022 and 2023. The court also found that Higgins, in one of these Instagram posts in 2023, had breached a contractual duty arising out of a deed of settlement between the two that she was to make any adverse comment about the parties involved. I just wanted to focus on that aspect of the judgment. It's primarily a defamation judgment, but I wanted to focus on that because, of course, in the workplace, we're regularly doing these terms of agreement where it is a good term for there to be mutual non-disparagement between the parties. So, in terms of this breach of contract claim that arose from a deed settlement breach between the two of them back in March 2021, Clause 10 of the deed contained a standard non-disparagement obligation, requiring both parties not to make any adverse, critical or disparaging statements, allegations or comments with respect to the conduct of any other party in any professional or personal capacity in any way related to the dispute. And the dispute was the dispute between the two parties and how they dealt with each other after Britt Higgins raised allegations of rape in Parliament House. Reynolds alleged subsequently that Higgins breached this clause when she published a 4 July 2023 Instagram story, which referred to Reynolds as her former boss, who has had to publicly apologise after defaming me in the workplace. The defence was that Higgins did not contest the construction of Clause 10, but denied breach and argued that the comment was factual. That is, that it merely summarised that Reynolds had apologised in 2021 and thus was not disparaging. She also denied there was a reasonable basis to fear further breaches. The court's finding in relation to that, Justice Tottle of the West Australian Supreme Court felt that Clause 10 extended beyond disparaging remarks to any adverse or critical comment related to the dispute, even if true. The Instagram post revisited the controversy settled in 2020 and thus breached the terms of the settlement deed. The court granted a declaration of breach and didn't make any order in relation to damages because there was already damages set aside in relation to the defamation for the same post, which I thought was an interesting one to bring to your attention because it highlighted, for me at least, the importance of complying with that standard non-disparagement term, which we often enter into, whether it's part of a negotiated departure or alternatively as part of negotiation of workplace claims that are brought. That is a common term, and it can be seen here where somebody breaks that term, the significant consequences that may flow from a breach of that non-disparaging term. Well, thank you again all for coming, and feel free to join us now for a drink and something to read if you wish. I'm happy to take any further questions if anyone has any questions about my presentation.